This is Suzanne. Suzanne maybe is with National YMCA. She offices out of Chicago. And she was actually involved in the first international mock trials we had 7 years ago. So we wanted to bring her back every so often to judge. So she's sitting in and being our evaluator today. And if you could go ahead and introduce yourself there, please.
First off, I just want to say hi, Suzanne. I really appreciate you volunteering to help us out today. This is it's a pleasure to have you, preside over the case. So thank you so much.
You're welcome.
Okay.
Hi, my name is Isha Bakshi. We are from Brampton, Ontario, Canada, from Central Field Secondary School. I will play the role of an alternate and
my name is Leah McBall, and I'll be representing the petitioner side.
Hi, we're having difficulty hearing that, so we might have to get closer to the mic.
Okay. You know what I'll do? I'll actually, maybe I will. Yeah, I might just end up moving the camera around if that's okay.
Yeah.
Okay.
No problem.
Can you hear? Go ahead.
Hi, my name is Isha Bakshi. We are from Brampton, Ontario, Canada. We are from Central Field Secondary School. I am playing the role of an alternate, and this is my team.
My name is Leah McBall, and I'll be representing the petitioner side.
My name is Stalteri. I'll be also representing the petitioner side.
Good afternoon. My name is Fatima Beatty, and I'll also be representing the petitioner.
My name is Harleen Chahal, and I will also be representing the petitioner.
My name is Joshua Ruflo, and I will be representing the respondent.
Good afternoon. I'm Jackson First Affiliate, and I will be representing the respondent.
Okay.
Did you need if you needed a clarification on names, we can do that whenever you want. But
Yeah, that'd be fine. You might want to just do it when they speak, and we'll catch on to it. Fine.
Sure.
Okay.
Hi, my name is Stephanie Garcia, and I will be representing the respondent today.
Hi, I'm Pamela Velasquez, and I'll be representing the respondent today as well.
Okay. And our two people be here in about 15 minutes, so we'll go ahead and introduce them when it's their time to speak when they're petitioner, okay?
No problem.
Okay, go ahead and I'll let Suzanne, you go ahead with your first speaker.
Okay.
Good afternoon, Your Honor. My name is Mia Bridwell, and I am here to argue that RJN was under custodial interrogation in the principal's office at Hillcrest Middle School with Officer Finch, the principal, and Ms. Clearwater. To be under custodial interrogation doesn't always mean for the suspect to be handcuffed. It also means the suspect was not able to take any action. In this case, RJN was bereft from the right to consult with a parent or attorney. As well as that, he was not informed that he had the right to remain silent and not answer any questions. In addition, under some circumstances, the suspect would be asked questions which are direct or are possible to result in implicit answers. According to factors that state whether an interrogation was custodial or not, it can be obtained that RJN was under custodial interrogation. These factors fall under a test used by courts called the totality of circumstances. This is made up of factors which are who asked the questions, how many officers were there, who else was there, who initiated the discussion, did the officer tell the suspect that the interview was voluntary, where did the questioning take place, did the officer use any force, physical restraints, or threats on the suspect, what time did the conversation take place, how long did it last, what was the style of the interview, and was the suspect free to leave at the end of the conversation. All these questions lead to whether the suspect was under custodial interrogation. First of all, who was asking the questions? Officer Finch, who was armed with a gun and baton, questioned him first. An armed officer can be more forceful and constraining. The chances at the sight of the weapons worried RJN and led to the confession are very high. Any 12-year-old would lie his or her way out of a room which had an armed officer with closed doors. As well as that, the situation was coercive due to the fact that the principal and guidance counselor were present. Such an environment can, and in this case, did lead to a forced confession. Another factor which determines whether an interrogation was custodial is if the suspect was aware that the interview was voluntary. In this case, RGN did not know that he also had the option to refuse answering any questions, and neither did the officer nor the principal and guardian confront or notify him about this right. In a 12-year-old's mind, it is fundamental to answer questions from a person of authority such as Officer Finch. It is also important to take into consideration whether force, physical restraints, or threats were included during the process. Similarly, in JDB versus North Carolina, the court believed that younger kids are more likely to feel pressure to speak to a police officer and would make an involuntary confession, and therefore the court case was dismissed. After being questioned about his phone password, the case states that the officer, and I quote, leaned forward so her face was less than 1 foot away from RGN. This caused RGN to be uncomfortable, as such a distance can be very intimidating. In such an incident, anyone would be scared and confused even if they were innocent. This fear that the officer apparently knows everything forced him to say that he sent the threat because he was intimidated and nervous, even though it was possible that he was innocent. The style of the interview can also prove that RGN was under custodial interrogation. The police officer accused RGN of sending the bomb threat by implying that there is no point of lying, as she may have copies of his text. After this incident, RGN confessed, but while the entire school was evacuated, he alone was kept in the office handcuffed. Overall, according to these factors, we can state that he was under custodial interrogation because the choice to go to the office was not voluntary. He was arrested at the end and was not allowed to leave. RGN had no contact with anyone outside of the office, and he was not informed about his Miranda rights until after the confession. During a custodial interrogation, the suspect is not free to leave. This occurred in this case as well when RGN was about to leave to go back to science class, but he was stopped by Ms. Clearwater. Since RGN was under custodial interrogation, it was required that he be read his Miranda rights before being escorted down to the principal's office. Miranda rights were formed under Miranda versus Arizona when a man was arrested from his house for allegedly kidnapping and sexually assaulting someone. Miranda confessed, but he wasn't told about his right to consult and was even sentenced to 20 years in prison. However, the Supreme Court of the United States repealed his conviction because he was not informed about his right to talk to an attorney or the right to remain silent. Since these were not given to Miranda, his statements were dismissed. Although the accusations are different in both Miranda versus Arizona and RGN versus North Reading, the suspects were bereft from their Miranda rights. Under the Miranda rights, RGN had the choice to remain silent. Since RGN did not know about this right, he went on answering all questions which came his way. Tommy answered out of fear due to in which way the officer was asking. Miranda rights also state that anything the suspect says will be used against him or her in the court of law. This greatly contributed to the judge's verdict of stating RGN to be guilty of a bomb threat. Since RGN did not know that he had the option to remain silent, he answered all questions, not knowing they can be used against him. Anything he said, truth or lie, was supporting evidence that RGN did not know he was providing. If RGN had been aware of this right, he would have been able to defend himself. Not only would he have been able to stand up for himself, but he also had the right to an attorney, which was violated during the interrogation. The case states that, and I quote, "At no point did anyone ask RGN if he wanted to have a parent or attorney with him, nor did RGN ask for a parent or attorney. Having someone who is educated about the rights of an individual would have been a beneficial support to RGN, as he was only a 12-year-old, and the chances that he knew about this right are very low. Since RGN was asked questions under custodial interrogation before the Miranda warning, the confession cannot be used against him in a criminal case, since it was involuntary. With all respect, Your Honor, as a speaker from the petitioner's side to this issue, I strongly believe that there was a fault in the court's decision to declare RGN guilty of a bomb threat, since he was under custodial interrogation throughout the process. Thank you. Counselor?
Yeah, go ahead and talk into this.
Counselor? According to school policy, the school must get permission from a student's parents before allowing a police officer to question the student unless there's an emergency. It doesn't appear that there is an emergency. So didn't the school, rather than the police, violate RJN's rights by allowing Officer Finch to question him without his parents' permission?
Yes, they did.
What was that?
Because
Yes, it did.
his rights were violated because his parents they tried to contact them, but they couldn't reach them. But even without that, before he was taken down to the office, they should have gotten his parents' permission to talk to him.
What was Officer Finch only asking RJN some hypothetical questions? Or why do those questions rise to the level of interrogation for Miranda purposes?
Because it was I guess since it was a bomb threat and she needed answers from them. That's why she was continuously asking questions. And it does state that Arjun shrugged. So I guess because of that, she had to keep asking questions, which got intimidating.
Okay.
Okay, next. You can say it. Next.
Next person.
Yay.
I guess it's
Hi.
Hello, Your Honor. My name is Sadni Patiranawaka, and I'll be illustrating how the tweet posted by RGN's account at 6:52 a.m. on Tuesday, May 1st, 2007, was not a threat to school safety. When there is a threat for the public safety, police officers are allowed to withhold reading the Miranda rights if a custodial interrogation occurs. In RGN's case, the judge believed that it was a risk to public safety, therefore allowing the exception of Miranda rights to be read. However, there is an error in law that occurs as the public safety exception is limited to occurrences where the public safety is believed to be at a true risk. In the case of Quarles versus New York, 1984, a police officer was told by a woman that a man assaulted her and was in possession of a gun in a nearby supermarket. Afterwards, the police officer found the respondent with an empty shoulder holster in that supermarket, matching the face of the description given. This caused the police officer to handcuff him. After handcuffing him, the officer questioned him as to where the gun was located. After locating the gun and officially arresting him, the officer read him his Miranda rights. During that time, the police officer took the possibility of the gun being hidden or still located on the premises, ultimately endangering the lives of the customer. This was seen as an exception by the Supreme Court as the public was under danger. If the Miranda rights were read to Quarles before the questioning, he would have not told the location of the gun, increasing the risk for the customers if located by a civilian and misused. Even though this is true, this exception can be seen in minimal cases, including that Quarles with New York case. But however, it does not apply to this very case. As there was no risk at Hillcrest Middle School, public safety exception should not have occurred. During Tuesday, May 1st, 2007, there was no emergency that occurred that risked school safety. After police officials verified the tweet, the respondents would not like an emergency or consideration of a threat. So only one police officer was sent to protect the school with children's lives at believed risk. This illustrates that even the police officials did not consider the tweet as a threat or a danger to school safety. Posts such as this do occur often, beyond this one case, Your Honor, and in most instances, they are false accusations. This fact, as well as RGN's young age and Twitter account name, was taken into consideration before officials took action that day. As RGN was 12 years old at the time and sent the tweet on an account called @SchoolSucks115, it illustrated his childlike mentality, which is seen through the simplified, incorrect spelling of the words and disinterest of ending school in the account name, as well as his very young age. From this, the officials inferred that the post was also a false claim, and therefore not a threat to the safety of the school. Due to this inference, police officials solely sent one officer. On the other hand, if they did truly believe that it was a threat to school safety, they would have taken further and more effective actions, such as sending a bomb squad or more officers to the scene. This would have helped eliminate the so-called believed risk or threat immediately. Even after the officer arrived, the school did not evacuate the children or teachers. This demonstrates that even the principal did not consider the possible bomb as a danger to the lives of the children and adults. If it was a threat to school safety, the children and teachers would have been evacuated as soon as they learned about the threat or tweet. And when the police officers considered it as a threat to their safety. Instead, students and teachers continued with their day and attended classes as usual. The actions taken by the authorities would not have occurred if it was a true emergency of the threat of safety, proving that the public safety exception in this instance to be invalid and that the school was not at a risk. Actions taken after the police officer arrived did not illustrate a school safety breach. Instead of considering the threat of a bomb, the police officer questioned RGN. Questioning RGN would not have kept the school safe. Unlike the Quarles versus New York case, the possible active bomb was involved. In the other case, the Supreme Court decided that not reading the Miranda rights was an exception due to public safety, as it would prevent anyone from using the gun if found. However, if this is not a direct parallel to this very case, to RGN's case. If the school was at a risk and the tweet was a threat to their safety, the state made an error that day. Interrogating the suspect for 15 minutes would not have protected the lives of the students. Instead, it would have endangered them, Your Honor. Wasting time as 700 lives are endangered would and should not have occurred if those lives were at true risk. Hence, a threat to school safety was not evident, as the tweet RGN posted was not a threat. This is vividly seen to the actions that were taken before the interrogation. Although actions were taken after the 15-minute interrogation, it is important to keep in mind that this is not evident nor taken into consideration when determining if the tweet was a threat to school safety. This is due to the fact that when determining an action due to public safety, one only considers the dangers before the interrogation and not after. Therefore, the tweet that was posted by RGN at 6:52 a.m. was not a threat to school safety because the school was not at a risk.
Counselor, may I ask you a couple of questions?
Yes.
Go ahead.
What if the officer was not present? Would the facts still support that RJN was in custody?
Can you repeat the question, please?
I said, what if the officer was not present? Would the other facts still support that RJN was in custody?
Yes.
Yep. Okay. Doesn't the fact that RJN knew to record the entire conversation with the guidance counselor, principal, and the officer on his phone indicate he knew he was in trouble and knew what was happening?
Your Honor, can I clarify if there was any evidence of that, of the recording of the case of the interrogation?
The transcripts are part of the facts of the case.
In the case given,
I didn't hear her.
Could you repeat that, please?
given, it does not illustrate that.
Okay. I'm done. Thank you.
Thank you.
May it please the court, Your Honor. I, Stephanie Garcia, partner Pamela de la Cesar, will represent the state in this case today. I will be speaking over the first question. Before I begin, I would like to refute, or I'm sorry, I'm speaking over the second question. Before I begin, I would like to refute some of my opposing counsel's arguments before I begin with my own. First, in New York v. Girls, they made this public safety exception for reasons like cases like these. Had Officer Finch taken the time to read him his Miranda rights, one, he would have had to be in custody or under interrogation to do that, which did not happen, as my partner will show. But also, it could have possibly put the safety of the public in more danger. Something serious could have happened at that time. Going on, the opposing co-counsels also bring up that if we felt that it was a true public safety exception, that we would have gone to further actions, there would have been more actions. But the thing is that they didn't want to freak everyone out. They wanted to see what was happening before they took those extreme measures and caused everyone to panic, because they don't want everyone to panic, because then it would have just been more of a mess. Also, the opposing counsels brought up that it was really a threat to the school it would have been after the questioning or before, but actually there was no threat after, as they had found out that there wasn't really a bomb and that it was just a joke. The real threat was before it happened and when it was posted at 6:52 a.m. We respect.
Sorry to interrupt. Is it possible, Michael, if you can just we're getting a lot of feedback through the microphone. Is it possible to maybe I don't know, like adjust the microphone or? No. Sorry.
It's no problem. Let's move this closer. Move it closer.
Does it sound better right now?
Yeah, actually. Does it sound good? Okay. Thank you.
Okay. Go.
We respectfully ask this court to affirm the lower court's decisions for the reasons the public safety concern was created when RJN published and called and the bomb threat was called into the school. To do this, we would like to offer a little impact calculus. First, the police and school administration worked hand in hand to avert a large problem in May 2007. Second, a state of emergency existed at the point of the publishing of the admitted threat. 3, due to the compressed time frame and the myriad of the concerns, police and school raced against time to ensure the safety of their students. Therefore, this leads to the most important question facing this court today. Did the alleged bomb threat endanger school safety when it was posted on RJN's Twitter account at 6:52 a.m., warning that a bomb would explode at Hillcrest Middle School about 6 hours later that day? My first point, a public safety concern was created with the publishing of this tweet, and this was reinforced when RJN called the 911 bomb threat to the school. Officer Finch was not required to read RJN his Miranda rights because the public safety exception to the Fifth Amendment applied. While the Miranda requirement protects the Fifth Amendment rights of criminal suspects, it has one significant exception, the public safety exception. In New York v. Quarles, the Supreme Court held that a police officer does not need to read a suspect his or her Miranda rights if doing so would endanger public safety. In Quarles, a police officer discovered that a criminal suspect gun holster was empty, indicating that a gun was likely somewhere in the supermarket. Without reading the suspect's Miranda rights, the police officer asked him where the gun was located. The suspect told the officer that the gun was by some empty cartons, allowing the officer to find the gun and prevent the shooting deaths of innocent bystanders. In such emergency situations, the public safety exception permits police officers to proceed in custodial interrogation without reading a suspect his or her Miranda rights. In this case, an emergency situation existed when a student threatened to bomb the entire middle school. The safety of all 700 students and more than 100 staff members were immediately in danger when the bomb threat was posted on Twitter at 6:52 a.m. The tweet was very specific. Not only did it indicate that a bomb was going to explode, but the tweet also included the date, time, and location of the explosion, as well as warning that this was not a drill. Public safety was at risk whether or not the bomb was real. If Officer Finch did not immediately question RJN about the bomb threat, she would have been unable to find the bomb before it exploded or make sure that there was no bomb in the school. Reading RJN his Miranda rights would have prevented Officer Finch from adequately ensuring the safety of the school, students, and staff. The fact that the bomb squad did not accompany Officer Finch to the school and that the school was not evacuated right away does not demonstrate a lack of emergency. As petitioner attempts to argue that an emergency exists whether or not the people panic or respond calmly. How people respond to a situation does not change the existence of that situation. Rather, it only affects the outcome of the situation. But the outcome is irrelevant here, as the public safety exception is not concerned with how safe the public is after the emergency has ended. It is concerned with only whether the public is at risk before an emergency has had a chance to unfold. As further indication that the police department recognized the emergency situation, Officer Finch at the school arrived at the school approximately 20 minutes after receiving the phone call. Given the emergency circumstances at Hillcrest Middle School on the morning of May 1st, the public safety exception justifies Officer Finch's actions in questioning RJN without reading him his Miranda rights. Which leads me to my second point. When an emergency or an emergency situation, can the police help the school investigate problems within the school? Yes, they can. Police Crossfire and Marquita M. 2012, these cases were very much the same. They both deal with the safety of the students. They both deal with the student and threats. They both have an SRO and deal with the police and school administrators actively questioning the middle school student about public safety issues. In 2010, the Quincy Junior High School Dean of Students heard that 15-year-old Marquita M. might have brought a weapon to school. The dean contacted the school resource officer, and together they pulled Marquita out of class and escorted her to the dean's office. In the office, the SRO asked Marquita whether she had anything she shouldn't have. Marquita initially said no, but she later admitted to maybe having a knife in her locker. She then admitted she had a knife in the pocket of her sweatshirt, which the SRO asked her to take out and place on the desk. The SRO identified it as a steak knife. A conversation then took place about why Marquita had a steak knife at school. At first, Marquita said she didn't know what she had planned to do with the knife, but she had later admitted that she was having problems with another student, TH, and they were supposed to fight later that day. When the SRO asked what might happen if the two fought, Marquita said that TH probably would have gotten stabbed. Marquita was then suspended from school and escorted off school grounds. The Illinois Court of Appeals held that Marquita was not in custody at the time of the question. Neither the circumstances nor the questions indicated a custodial environment. The court reasoned that Marquita was 15 years old at the time and had previous contact with police when she was suspended from a different school for bringing her to school. Also, she was questioned in the dean's office, not the police station. And throughout the questioning, she was not handcuffed, physically restrained, or searched. At no point did Marquita ask to speak with a family member. Only one SRO was present, and the SRO did not display his weapon or exhibit any force. Further, the SRO's questions were not confrontational. The questioning was not lengthy, and the SRO did not badger Marquita or continue to interrogate her with hypothetical questions. Rather, his questions were inquisitory, not accusatory. For instance, the SRO asked, "What would have happened if you and TH got in a fight?" rather than, "You were going to stab TH, weren't you?" Considering all the circumstances, the court held that Marquita was not in custody. Miranda warnings were not required. The same should apply here as well. For these reasons, we respectfully ask this court to affirm the lower court's decision because this was a matter of public safety. For the reasons stated above, the Supreme Court should affirm the decision of the North Reading Supreme Court and hold that 1, Officer Finch did not violate RJN's Fifth Amendment rights, and 2, the juvenile court correctly denied RJN's motion to express his confession at trial. Thank you.
In terms of applying the public safety exception, if Officer Finch was so concerned about the bomb threat, then why wasn't the whole school evacuated immediately upon learning of the tweet?
Well, Your Honor, like I had mentioned earlier, they wanted to take precise actions upon this. They didn't want everyone to panic and freak out, and it just be more of a chaos, because then that really could have set off the bomb threat, or set off the bomb, excuse me, as they did not know where it was. So they were trying to gather that information before taking it to extreme measures, but they also wanted to take in consideration of the public distraction.
Okay. Thank you.
Thank you.
May it please the court, Your Honor. My name is Pamela de la Cerda, and I represent the petitioner in this case. Your Honors, this case is about public safety and the well-being of our local schools, teachers, staff, and students. I would like to begin my speech with first refuting a couple of my opposing counsel statements. Here, the petitioner argued that it was the principal and the school who violated RJN's rights, not Officer Finch, where she was simply asking non-accusatory questions to ensure both the safety of RJN and the school and the staff. As well as they say that we must look at the totality of the circumstances in this case. And in this case, we see that those circumstances are no accusatory questions, and there was never any physical restraints as the petitioner says there needs to be in order for there to be custody. He was never forcefully held back, nor was he forced to stay in that room. He stayed on his own free will. Therefore, he was not owed Miranda warnings, or Miranda warnings are only owed when the suspect is in custody. Which leads me to my first point, that there was never a custody. As the Supreme Court has established, a suspect is in custody when a reasonable person in their position feels that they were not able to leave. In this case, we must apply JDV versus North Carolina. Here, it was held that a suspect's age is one of the factors that we must consider in determining whether the suspect was in custody. In this case, RJN was neither in custody nor under an interrogation. Therefore, Officer Finch was in no obligation to inform RJN of his Miranda rights. RJN simply confessed to tweeting the bomb threat on his own. Therefore, RJN's confession is admissible in trial. Here we see that a reasonable person in the suspect's position would feel free to leave. The suspect's age is one of the factors, and here we see that a 12-year-old not being forced to stay, both physically, there was no accusatory questions ever being asked. He was able to leave, and he was allowed to do so at that time. While the court, in JDB, as I have mentioned, a court recognized that all the interviews of criminal suspects have some coercive aspect in them, and a confession that is voluntary is admissible. Given these circumstances, a reasonable 15-year-old would have felt free to leave in RJN's position. In this case, the circumstances clearly show that the environment in the principal's office was not very coercive. RJN was in a situation where any reasonable person would feel free to leave. For example, the door was not even closed, where it would indicate that RJN was in custody. Most conversations between the school administrators and the students take place behind closed doors. Regardless, they keep their information confidential, and this is exactly what they were doing in RJN's case. A closed door, however, does not signify that RJN was in custody or was being interrogated. Furthermore, the petitioner's arguments that a president of a school administrator placed RJN in custody is plainly wrong. For purposes of Miranda warnings, custody is a question that relates only to the police, not the school principals and the guidance counselors. Second, Principal Weatherby and Ms. Clearwater did not make the situation any more intimidating for RJN if he would have been alone with Officer Finch. Ms. Clearwater was a comforting presence in this case. And right here, we can cross-apply this to JDB versus North Carolina, where a police interview does not take place in custody, does not raise the risk of a suspect's confession being involuntary. The environment in the principal's office did not raise the risk that the suspect's confession was involuntary. Here, the environment in the principal's office was not highly coercive. These circumstances indicate that RJN was not in custody during the question, meaning Officer Finch was not required to inform RJN of his Miranda rights. Which leads me to my second point. There was never an interrogation. A suspect is under interrogation only if two requirements are met. First, a police officer must say or do something that is reasonably likely to cause the suspect to incriminate himself. Or secondly, a police officer must intend for these words or actions to cause the suspect to incriminate herself. Neither requirement is met here today. Officer Finch said and did nothing that was reasonably likely to cause RJN to confess into sending in the tweet. Her questions were open-ended. They were not accusatory whatsoever in this case. For example, Officer Finch said, she asked, "It's a tweet sent by School Sucks 115. Do you know who that might be?" She was not accusatory whatsoever in her questions. As we can see, she did not rather phrase her question. "It's a tweet sent by School Sucks 115. That's your account, isn't it?" That would constitute as accusatory, and that is not what Officer Finch did that day. Her questions were not likely to cause RJN to confess. Furthermore, the petitioner's assertion that Officer Finch lied to RJN is completely false. At no point did Officer Finch lie to or mislead RJN. Her questions about what he would say if she told him she had a record of his text are simply just not accusatory. Because none of Officer Finch's words or actions are reasonably likely to cause RJN to confess, RJN's questioning did not raise to the level of interrogation. For these reasons, my partner, which has previously described the emergency situation. We respectively ask this court to affirm the lower court's decision because there was a state of emergency that existed at Hillcrest Middle School, and RJN was not in interrogation during this time. Thank you.
Counsel? Doesn't the fact that RJN tried to leave the principal's office and was told to sit back down clearly indicate he was in custody?
No, Your Honor, for he was not forced to stay and sit down. He simply chose to do so on his own free will, and that just shows that he did not feel like he had to stay there. He could be able to leave.
Is it really reasonable to think that a 12-year-old might be able to build and produce a bomb?
Well, Your Honor, here we have to establish safety, and whether it was or was not reasonable, the school did not know at that time. For the reasonable thing to do was to act and to make sure all the students are safe, all the faculty is safe, and that was the reasonable thing in this case.
If we find RJN was in custody but not interrogated, is that okay with you?
Well, Your Honor, it's not what's okay with us. And can you repeat your question? I'm sorry.
If we find that RJN was in custody but not interrogated, is that okay with you?
No, Your Honor. Right here, it's not what we find that we are okay with. It's whether this safety was established in the school and the fact that RJN's rights were completely protected all the way through.
Thank you.
Rebuttal.
Both your students were respondents, correct?
Yeah.
Yeah. Are you okay to hold it? Yeah.
Okay, good afternoon, Your Honor. My name is Fatima Bidi, and I will be rebuttaling the points brought up. Before I start, I would like to address the issue of the recording, which was brought up. There were in this exact proof that says that a recording, that there is exact proof of a recording in the court. So we'd like to say that there is no.
It's breaking up really bad. Could you get a little closer? Thanks. Okay. Go ahead now.
Would you like me to repeat what I said?
Just go ahead and tell us your argument again, please. She'll hear.
Okay, yeah. So we would like for you to dismiss the fact of the recording, as there is no proof in the court of the exact recording. So that point is dismissed. Okay, so my friend from Texas, she brought up the point of New York versus Quarles and how an exception was made, as they didn't, and I quote, they didn't want to freak everyone out. And the real threat was before it happened. But if you're looking at public safety, you're ensuring the safety of the citizens. You're not going to worry about if they get freaked out or not. You're trying to save the lives of a copious amount of people. You're not worrying about you're not worrying about their emotional state as of this point. You're worrying about their physical safety. So, as my friend stated, that there was an emergency existed and there was a race against time to ensure safety. Specifically referring to the RJN case, the officers took their time to do the interrogation. Nobody was evacuated right away, and this proves that that they didn't see it as a threat, and it is being argued in court that this was a threat. But the fact that they took their time, that despite there being a apparent bomb, which was found out to have, which the threat was posted before school even started, the threat had been posted, and the lives of 700 students were at risk. However, as my team member stated earlier, no school continued regularly. Nothing, no apparent actions, although you argued that you wish to ensure that the right circumstances existed. When the lives of 700 students are at risk, I don't think there is a question of worrying people and not freaking them out, as there shouldn't be, as everybody has the right to safety. And you stated that you wanted to respond calmly to concerns. And then the Henry Margarita case, I'm not sure if I'm pronouncing it right, that case was brought up. And in this case, the accused was found with a knife. And although similar circumstances exist, a knife and a bomb threat are two completely different things. And this knife came out of the victim. It came out of her pocket afterwards. And the court ruled against her, that she was not under custodial interrogation. And yes, that's relevant to her case, but in our case, we're talking about a bomb threat that was posted 6 hours before school started, in comparison to a knife which came out of a student's pocket. And I feel like this is not a complete proper parallel. And so that kind of comparison does not make any sense to me. And so if the officer was, why wasn't the officer? So the school was not evacuated. And if the officer was concerned that the school should have been evacuated, and although you again stated that you want to take precise actions, you don't want to freak out people, the safety of the people is more of a risk. And now referring to the second speech that was made, I am very confused as if we are even referring to the same case, as you referred to the RJN to be 15 years of age, as the case states that he was 12 years of age. And also the questions about the open-ended questions, you stated that the officer did not, they only asked open-ended questions, whereas through her questions, the officer implied and even said, and I quote from the case, that, what if I told you, RJN, that I have a record of your text messages? If I have a record of your text messages and phone calls from the bus this morning. And my friend clearly stated that the questions were open-ended, but this question does not seem open-ended to me. So, and then you argued that
Please excuse the interruption. Can all ultimate Frisbee players please come down to the lobby at this time?
Okay, and you argued that he wasn't, for custodial interrogation, you need to be forced to stay there. And you argued that he wasn't forcefully required to stay there, but I beg to differ, as he was escorted by the police into the office with the principal and the guidance counselor present. And so he was required to stay there. He didn't have a choice. So he couldn't just get up and leave. Otherwise, the police would have suspected more, and he would have been in deeper water than he already was in.
Okay. Good evening, Your Honor. My name is Harleen Chahal, and I'm a representative of the petitioner. And today I will be providing a rebuttal against the state's argument. The state's attorney claims that RGN's tweet was a threat to public safety because of the details it included. But Your Honor, I'm here to remind you that you can't just take a threat from social media seriously and consider it as a threat. For one, like I mentioned before, the so-called threat was published on a social media platform, and everybody knows that everything you read on social media is not always factual. For example, if a teenage girl tweets out, "I would kill to meet Justin Bieber at his concert this Friday," although this tweet, much like RGN's tweet, includes a date, no one would take this girl seriously, as we know that her saying that she would kill to meet Justin Bieber is just a figure of speech. Now, I know that RGN's tweet is a little more serious than the example I'm providing, but what is there to say that RGN was also not being figurative when he used the word bomb? When talking about a test they are sure they failed, students often say, "I bombed that test." Or when confronted about why they are acting so strange, teens often say, "Oh, it's because I'm bombed," referring to the fact that they are drunk. As you can see, teenagers are always coming up with new figures of speech. Some that are very popular and known by not just teens themselves, but also by officers, and some not so well known, proving that sometimes something you find on the internet, no matter how much detail it includes, isn't always true. Now, the possible meanings of bomb I shared with you are very popular meanings, but what is there to say that RGN's meaning of bombed in his tweet, his meaning could mean numerous things that aren't so popular, including the word pumped. If the tweet read, "Hillcrest, get ready to get pumped," rather than bombed, would you actually think that RGN was gonna pump his school? Of course not. So how do we know that RGN was not simply being figurative? Is it because he admitted to sending the tweet? Well, Your Honor, admitting to sending that tweet only confirmed that he sent it, not that the tweet meant that he was going to actually bomb his school. You may ask now, well, why didn't RGN just tell the officer that he did not mean to bomb his school in a literal sense? Well, like I mentioned before, Officer Finch was being extremely intimidating. So RGN might have just been extremely scared. Who wouldn't if a police officer was violating your personal space? As for the hashtag, this is not a drill. Kids these days interpret this to mean hashtag not lying or hashtag telling the truth. So now that I've decoded RGN's tweets for you, you tell me, Your Honor, does the tweet 6th period today, get ready to get pumped, Hillcrest, hashtag not lying sound like a threat to you? We're not disputing the fact that this tweet was sent through RGN's Twitter account, but rather we are merely asking the court to be cautious about the intent of his tweet. Thank you, Your Honor. Yeah, she's coming.
No, I'm good. Thank you, counselors. So they have 4 different people.
It's yeah. Guess we're ready for the next one then. I'll have our 2 girls stand up here and introduce, and then we're petitioners and you are respondent. And then at the very end, we'll let Suzanne give some comments.
Michael?
Yes.
If possible, could we wait about maybe 5 minutes or so? We're gonna have a transition in classes, and then there's gonna be a lot of noise over the PA and stuff. Is that okay if we get settled?
Okay, just tell me when you're ready.
Okay, fantastic, great. Okay. Can you hear us?
I can hear you fine. I put you on mute when that bell rang.
Oh, okay. Okay, we're just switching places and we should be off in like 20 seconds.
Okay, good. And then we'll introduce ourselves when we're ready to go then.
Great. Okay, we're ready to go.
Hi, my name is Cecilia, and I will be petitioner today.
Go ahead. Introduce yourself.
Oh. Hi, good morning. My name is, afternoon, no, morning. My name is Reese Rodriguez, and I'll be partnered to my partner, Celia Perez, and we'll represent the petitioner, RJ, and TV today.
Say hi.
May it please the court, my name is Cecilia Perez, and I represent petitioner RJN in this case today. At this time, I will speak for 7.5 minutes on the first point of error, and my partner will speak for 7.5 minutes on the second point of error, and we will reserve 5 minutes for rebuttal. Your Honor, this case is about police creating a coercive atmosphere in which they cause a 12-year-old student to confess to a crime without, 1, reading him his rights, and 2, giving him the ability to have legal representation. RJN respectfully asks this court to reverse the lower court's decision, for the Supreme Court should reverse the decision and hold that 1, Officer Finch did in fact violate RJN's Fifth Amendment rights, and 2, the juvenile court incorrectly denied RJN's motion to suppress his confession at trial. Now, the Fifth Amendment guarantees all criminal suspects a privilege against self-incrimination, and it was included in the Bill of Rights to acknowledge and balance the coercive power of the state. Now, the Fifth Amendment protects self-incrimination throughout 2 important points, which is the right to remain silent, and 2, the right to counsel. Now, RJN was in custody as soon as he was pulled out of class. He was taken out of class for the purpose to be interrogated by Officer Finch. Now, interrogation has been defined as questioning or its functional equivalent, that is, statement intended to elicit an incriminating response by the subject. Now, taking a look into Rhode Island v. Ennis, the court says that we must look at all of the circumstances surrounding the suspect and look at the way that the officers, we must look at the way that the officer acts to the suspect and the way that the questions are worded. Now, RJN felt as in JDB v. North Carolina, it says that to determine whether a suspect was in custody, we must know if a reasonable person in his or her situation would feel free to leave. RJN felt as if he wasn't free to leave because he was sitting around other 3 adults, Officer Finch being armed less than 12 inches away from his face, asking intimidating, accusatory questions to him. He felt as if he wasn't free to leave. And now, he did try to get up to leave. However, we must take into account that he was told to sit back down.
Sorry about that.
Did not feel free to leave at the time. RJN wasn't being interrogated at the time. Now, we must take a look at the way that Officer Finch worded her questions. Now, she was bringing up false evidence at the time when she asked, "What if I told you, RJN, that I have a record of your text messages and phone calls from the bus this morning? Would you tell me that whoever stole your phone and tweeted from your account also texted and called your friends?" Now, RJN believed from the instant that she asked this question, he knew, or he immediately thought that Officer Finch already had proof that he was the one that had posted the tweet. So because we take a look back towards the beginning when Officer Finch was there, she had handed him a paper and asked, "This is printed from Twitter. Do you recognize this?" Now, whenever Officer Finch did this to RJN, he thought that she already had records and proofs. So when she made this question that if she had a record of the text messages and phone calls, RJN was, it was a lie that Officer Finch used. It's a tactic that she used in order to get RJN to confess. And she also said, "Would your story change if I told you I have a record of the text messages you sent and phone calls you made this morning? If I told you I know who you texted and called before and after the tweet and what those messages said?" Therefore, already accusing RJN of posting this tweet because she is saying the text messages you sent and phone calls you made. And this is something we must look at today in the court, that Rhode Island BN has ruled that we must look at all of the circumstances, interactions made between an officer and the way that even the questions are worded. Now, school policy or section 1321 says that officers must talk to the principal. However, we must take into consideration 1322B that says if a student is under 13 years of age, a parent's or guardian's notification and permission is required before any interview or interrogation will take place unless clearly there was an emergency, which in this case there wasn't. And this wasn't done. Now, respondent may try to argue that they did make an attempt to try to reach RJN's parents. However, did they ever really contact them? No. And they also, if they weren't able to contact them, they obviously weren't able to get the parents' consent in order to interrogate RJN. Now, another point is juvenile warnings. Now, before interrogating a juvenile, law enforcement must inform juvenile of his or her rights. In addition to the usual Miranda rights or warnings, a juvenile must be advised of the right to have a parent, guardian during the questioning. If the suspect is under 18 years of age, such as RJN, which he was 12 at the time, a parent, guardian, or attorney must be present when the juvenile is being interrogated. Otherwise, any statement shall be suppressed. Now, in Miranda v. Arizona, it does say that all people or suspects are entitled to Miranda warnings. And recognizing the importance of these rights, the Supreme Court held in Miranda v. Arizona that police officers must inform criminal suspects of the Fifth Amendment rights before the suspect is placed under custodial interrogation, which is what happened in this case today. These rights are commonly known as the Miranda warnings, and failure to inform a suspect of these rights is a violation to the Fifth Amendment. And when a police officer violates the Fifth Amendment to obtain a suspect's confession, such as Officer Finch did to RJN in questioning him and bringing up false evidence to him, that confession cannot be used as evidence against the suspect in court, and meaning that we shall have a new trial when the judges or jury won't be able to hear RJN's confession because it was illegally obtained by Officer Finch, making these accusatory and bringing up just false evidence to him by asking the questions that she had made. And for these reasons, we ask that you vote to overturn the lower court's decision because clearly RJN's Fifth Amendment rights were violated because he was under custodial interrogation, and Officer Finch failed to inform him of his rights, which are constitutionally entitled to everyone under Miranda v. Arizona. Thank you.
Counselor, I have some questions for you. According to school policy, the school must get permission from students' parents before allowing the police officer to question the student unless there's an emergency. And you did state that there was no emergency. So didn't the school, rather than the police, violate RJN's rights by allowing Officer Finch to question him without his parents' permission?
Not at all, Your Honor. We must take into consideration that police officers do have a procedure they must follow. And in this case, Officer Finch knows under the law that there's juvenile warnings, such as I mentioned, that if it is a student or any person that is under 18 years of age, and RJN was 12 at the time, it is still required to get parents' consent and have an attorney or legal representation there at the time. And Officer Finch failed to do these important steps, and knowing that Miranda v. Arizona still applied to RJN.
And was Officer Finch only asking hypothetical questions? So why raise all of this based on Miranda purpose?
Well, we must look at how she actually worded the questions, such as Rhode Island v. in its role, that we must look at the way that its interactions are made and the wording of it. And what happened here was that she was bringing up false evidence and making RJN believe that she already had proof of the records and stuff.
Thank you.
Are you ready, Your Honor?
Yeah.
Opponents ready? May it please the court, Your Honor, I, Mr. Rodriguez, will present the petitioner, RJN, in the case before the court today. Your Honor, I will address the second point. Did the alleged bomb threaten endanger school safety that was posted on RJN's Twitter account at 6:52 a.m., warning that a bomb would explode at Hillcrest Middle School about 6 hours later that day? Now, Your Honor, we resoundingly and firmly disagree with the lower court's decision and respectfully request this court to reverse this lower court ruling for the following reasons. 1, Officer Finch created the situation due to her inability to handle an investigation properly. 2, there are 2 main rights in jeopardy today. And 3, the respondent's logic contradicts. So in New York v. Quarles, the public safety exception was created to allow officers to skip the reading of Miranda rights when the public safety is in danger, cross-apply all of the points made by my co-counsel. Now, the facts in RJN's case do not indicate that a single public emergency existed. In RJN tweet at 6:52 a.m., his Twitter account read, at school sucks 1115 says 6th period today, get ready to get bombed, Hillcrest, hashtag this is not a drill. Now let's take a closer look into the tweet. None of the words used in that tweet were illegal. And if we look at the actual threat that was supposed and alleged in the tweet, they refer to bomb as the actual threat. The bomb can be open to interpretation. Now, the definition of bomb can apply to the action of failing, moving quickly, a state of intoxication, or an attack. And in this case, none of those apply. The First Amendment to the United States Constitution prohibits the making of any law respecting the establishment of religion, impeding the free exercise of religion, abridging the freedom of speech, infringing on the freedom of press, interfering with the right to peaceably assemble, or prohibiting the petitioning for a governmental redress of grievances. Now, of course, let's take into account the fact that if we were to, of course, rule against RJN like the lower court, we are depriving our citizens of their First Amendment rights. The tweet was simply a form of expression that RJN used as a social media outlet in order to express a feeling. Now, if we look at the limits under the First Amendment, the limits do not apply at all, considering that the limits usually focus on whether there's some kind of threat towards the people. And in this case, the threat was not towards the people. It was simply a form of expression that my client did. Now, the correspondence logic contradicts for 2 reasons. The tweet did not trigger, and RJN was in custody when the emergency was going on. Now, if a true emergency had existed and was handled adequately, proper procedures would have been followed. On top of that, the questioning of the tweet, as opposed to the alleged bomb itself, was in keeping the school safe. Again, they were addressing the tweet instead of focusing on whether or not there was an actual threat. So, of course, that would be a logical fallacy of half-truth and just finish the job. They're focusing on Officer Finch's job and whether or not Officer Finch was able to finish her job. Yes, she finished her job, but she did following on proper procedures. And knowing that as a professional, she must understand that, of course, as a police officer and as a server of the community and its citizens, she must follow the proper procedures, and she should have granted RJN his rights. So, Your Honor, if we were to, of course, rule on the respondents, clearly we would be depriving our citizens of the First Amendment and Fifth Amendment rights. Now, when determining whether the public safety exception applies, courts look at whether an emergency existed before custodial interrogation took place, not after. Since the school safety was not at risk, the public safety exception does not apply, making this a false analogy. Now, of course, the respondent may try to attempt to make several connections with other cases, but in this case, there's no connection to RJN in the situation that we're looking at today. Why? Because in this case, there was no weapon and there was no threat. So, of course, they cannot argue that there was a public emergency when clearly there was no weapon or a threat. My client the only thing that my client really admitted to was sending the tweet. And of course, under the First Amendment, the tweet was simply a form of expression. So, of course, if we were to rule on the respondent side, we would be abridging the freedom of speech, which is against the First Amendment. Now, following the Fifth Amendment, of course, I've said several times that it's established that there was no public emergency, and cross-applying all of the points that my co-counsel made. All of the intentions of the officer must be taken into place, considering if we were to cross-apply Rhode Island v. Innis, in which the court ruled that we must look at the situation and the way of the intentions the police officer are asking the questions, in which all the questions were not hypothetical, and of course there was one that was inquisitory and accusatory and 12 feet away from my client. Now, onto the logical fallacies. They may try to use a scare tactic, trying to say that the public safety was in danger and we must look at the well-being. But of course, we cannot give our rights in order for safety. Benjamin Franklin once said that those who give up their rights for security don't have either of them. So of course, we cannot simply go following this logical fallacy of scare tactic or the just in case logical fallacy, in which they are attempting to argue that just because there might be an emergency, we must give up our rights to give the police the ability to do their job. That's not right. What's right is the police officer must have done the proper police procedures and followed correct police procedures. And of course, we wouldn't be standing here today if that had happened. And of course, all of this is due to Officer Finch's inability to handle a situation and to handle an investigation properly. For these reasons, and these reasons alone, we pray that you uphold the rights of all of our citizens and stay true to the Constitution. Thank you, Your Honor.
Counselor, if age matters, shouldn't his comfort and being familiar with the school and the administrators suggest that he was not in custody?
Well, Your Honor, since considering the fact that when it comes to an adult situation, and considering there were 3 adults regarding the situation, it was a very intimate. Environment. Of course, my client was 12 inches away from the officer who was asking questions. So even if he was familiar with 2 other people, the person that was in front of him, the officer, Officer Finch, she was 12 inches away from him, making it a coercive environment.
Thank you.
Thank you.
First respondent.
Your Honor, my name is Joshua Rupo, and I'm here joined today by my friend, Jackson Stalteri. We are here to prove 2 things that verify the original ruling of RJN's case was in fact correct. I will prove to you that RJN was not under custodial interrogation, hence there was no need for him to have been read his Miranda rights by Officer Finch. And Jackson will soon prove that RJN's bomb threat did for a fact endanger the safety of the school and all those that attended it. Now, before I proceed, I'd like to address some of the comments made by those that oppose our ideas. It was said that RJN was not under custodial interrogation, but they said that RJN was under custodial interrogation as soon as he left. This is not true, considering a custodial interrogation would not have begun as soon as he left the classroom. It was also said that parents are needed to interrogate a student that is underage, and I'm here to prove that RJN was not under interrogation, therefore parents would not be needed. And it was also said that the information obtained from RJN was illegally acquired, seeing as he was under custodial interrogation. And once again, I will soon prove that RJN was in fact not under custodial interrogation. Custodial interrogation, by definition, is a questioning period in which the ability to act in a significant way is taken away, and one is questioned with the intent of producing a response that would incriminate. With the use of various other cases, I will present to you reasons as to why the questioning period of RJN was not to be considered custodial interrogation. I intend on conveying the topics of his abundant amount of freedom, the lack of intimidation he faced when compared to others, and the short duration of RJN's exchange with Officer Finch. Custodial interrogation has multiple factors that decide whether or not questioning is registered as custodial interrogation, and I'm confident in the fact that after I prove that RJN's questioning has too many flaws to be considered custodial interrogation, you too will see the 2 issues in the same way that Jackson and I do. Unlike within a custodial interrogation, RJN was given a great deal of freedom when asked to go down to the principal's office. RJN was not confined, did not have his body checked, and most of all, he had the choice to go down. Even though he may have felt as if he was forced, legally and in the eyes of the law, he did have the choice to go down to the principal's office. I'd like to tell you about the case of SG versus Indiana. It is a similar case where a similarly aged student, SG, faced a similar option. The court in this case decided that SG's choice to go down to the office to be questioned was good enough reason for his similar questioning period to not be considered custodial interrogation for Miranda purposes. So if SG's ability to have a choice to attend his questioning was a deciding factor in his ruling, wouldn't it only be logical to apply the similar factor here in this case? Those of you that are also familiar with the SG versus Indiana case would know that SG was questioned by the principal in the presence of a police officer, unlike RJN, who was questioned by a police officer in the presence of a principal and a teacher and a guidance counselor. Even though RJN was questioned by the officer, this is still not sufficient justification for considering his questioning as anything else but a questioning period. In the case of NC versus Kentucky, the state concluded that a confession in the presence of 3 armed police officers in the back of a squad car was not enough intimidation to be considered his presence there and confession custodial interrogation. Due to the so by this logic, it seems nonsensical to consider the amount of pressure RJN was facing as a deciding factor as to why he was supposedly under custodial interrogation. Okay. And then, yeah, it's hard because if the presence of 3 police officers is enough, the presence of 3 police officers is far more intimidating than the presence of a principal, 1 police officer, and a guidance counselor. So by making the notion that RJN was under too much pressure or enough pressure to consider his questioning period as custodial interrogation, it just defies all logic. In the case of Inri Marquita M, a 15-year-old student carrying a steak knife was questioned about the possession of the weapon. In this case, Miranda rights were found to have not been violated, and one of the very reasons for this was the fact that the questioning period did not take a prolonged quantity of time. Without a doubt, RJN was not under custodial interrogation, so we had no reason to berate his Miranda rights. His interrogation lasted only 15 minutes, unlike many others who had their interrogations last several hours in the other cases.
Counselor?
Pardon?
Can I ask you a question?
Yes, you may.
You argue that RJN was not under interrogation because Officer Finch didn't lie to get his confession, but she suggested.
No. Oh, sorry, carry on.
But suggested she had evidence that she really didn't have, a record of his text messages and phone calls from the bus that morning. Didn't she make this up just to get him to confess? And isn't that interrogation?
Oh wait, were you like originally in the question? Did you ask if I said that she didn't lie? That's how you began the question, correct? I never made any comment as to the actual dialect between Officer Finch and RJN.
Okay.
But to answer your the lying, or the supposed lying, I would not consider that enough reason, considering that's only one factor out of the many that make up custodial interrogation. Custodial interrogation has far too many factors for only one being true to make it custodial interrogation. It's just a questioning period in which the police officer did something questionable. It's not enough to consider it custodial interrogation. RJN did not have his body checked. He had his phone on him, and he was not handcuffed during the actual questioning and speaking between the police officer and himself. By this means, calling it custodial interrogation makes absolutely no sense.
Thank you. You may continue.
So yeah, if RJN was really under custodial interrogation, don't you think he would have been handcuffed? He would have had his body checked before entering. RJN had his phone on him. Under any means, and custodial interrogation, why would anyone be allowed to carry their phone on them? And then, so even if by some odd means, RJN's questioning period was considered to be custodial interrogation, she still wouldn't have had to been read his Miranda rights, seeing as his bomb threat on Twitter did pose enough threat, as Jax was to explain. Thank you.
Thank you.
Do you have any questions?
I'm good.
Good afternoon, Your Honor. I'm Jax Escodia, and I will be addressing the second issue of how the tweet posted on RJN's Twitter account at 6:52 a.m. warning that a bomb would explode at Hillcrest Middle School about 6 hours later that day endangers the school safety. Your Honor, as representatives of the petitioner argue that RJN was in custody and under interrogation, and how Officer Finch was constitutionally required to inform RJN of his Miranda rights, but she failed to inform RJN of his Miranda rights, leading to violation of his Fifth Amendment right, making his confession forceful and inadmissible. But his confession is admissible because while the Miranda requirement protects the Fifth Amendment right, there's one exception, public safety exception. According to the Supreme Court, public safety exception is triggered when police officers have an objectively reasonable need to protect the police or the public from immediate danger. In Quarles versus New York, 1984, the Supreme Court held that a police officer does not need to read a suspect his or her Miranda rights if doing so would endanger the public safety. In Quarles versus New York, a suspect was questioned by a police officer without the officer stating the suspect his Miranda rights, as the suspect hid a gun in a supermarket and intended to shoot people at the supermarket. To ensure the public safety, the officer bypassed the Miranda rights, and the Supreme Court of USA made an exception to the Miranda requirement, as the Miranda rights were not to be read if an emergency situation exists. In this case of RJN versus State of North Riding, an emergency situation existed, as the safety of 700 students was endangered by the bomb threat posted on Twitter at 6:52 a.m. by the account at SchoolSucks115, which was owned and controlled by RJN. The tweet was very detailed, as it stated, and I quote, 6th period today, ... get ready to get bombed, Hillcrest, hashtag this is not a drill. The tweet included the date, the time, place, and the threat, which is enough to make a situation an emergency situation. It also included a warning, hashtag this is not a drill, which makes the situation even more dangerous. When Officer Finch was questioning RJN, she proceeded with the questioning without stating the Miranda rights, because that would have delayed the process of her finding the bomb at Hillcrest Middle School before it exploded. With regards to the safety of 700 students and staff, she neglected the Miranda rights, which is supported by the law in emergency situations like the one at Hillcrest Middle School on May 1st, 2007. The public safety was in danger, as there was a sense of panic within the personnel who read the bomb threat on Twitter. They believed that their lives were in danger, and this is shown by the phone call the Hillcrest Police Department received at 7:22 a.m. on the morning of Tuesday, May 1st, 2007. As the unidentified caller believed that their safety was in danger by the RJN's tweet, and they took the move and called the police department because they were not feeling safe enough. So public safety was in danger, and this was evident by the phone call by the unidentified caller's panic when he called the police department. As the petitioners argue again that the police department of Hillcrest didn't take the appropriate measures as a respondent was not like an emergency, but we strongly believe that appropriate measures were taken to solve the emergency situation at Hillcrest Middle School. At 7:22 a.m. on the morning of Tuesday, May 1st, 2007, an unidentified caller called the Hillcrest Police Department and informed them about the bomb threat at the local middle school. At 7:45 a.m. of Tuesday morning, a police officer of the Hillcrest Police Department arrived at the Hillcrest Middle School. The duration between the phone call and the arrival of Officer Finch was relatively fast, as she arrived 23 minutes after the phone call. This is considered fast because a lot was happening in that 23 minutes, as Hillcrest Police Department had to make sure the call was not a prank call and had to verify that the tweet was real. Also, the distance between the police department and the middle school is not specified, but one can infer that it is relatively fast for a police department to check and sent an officer in around 20 minutes. Therefore, the emergency situation protocol was followed by the Hillcrest Police Department. Again, as the petitioners argue that appropriate measures were not taken once the interrogation started, but we believe that appropriate measures were taken when she was talking to RJN, as even in such a dangerous situation, she followed the procedural law as she was identifiable with her full police uniform, with her baton, and with her gun visibly attached to a belt, and respected the space of the accused, in this case RJN, by making no direct contact until he was arrested for making a bomb threat. Upon arresting RJN, the officer read him his Miranda rights, continuing to fulfill the duties required of her. As the petitioners argue that the duration of Miranda rights are not that long, and they should have been read by Officer Finch before talking to RJN, we, the respondents, believe that although it may seem like reading out 4 laws, it is considered time-consuming when a potential bomb is present on the site, and all measures must be taken to protect the lives of the citizens. With respect to Officer Finch, we believe that she, as a legal law enforcer, fulfilled her duty and saved the students of Hillcrest from an alleged bomb attack, which would have endangered the school safety. Considering the facts, Officer Finch's work can be considered outstanding, as she resolved the issue and saved the lives of 700 students and staff in a little more than an hour. Your Honor, the public safety was in danger as an emergency situation existed when RJN threatened to bomb Hillcrest Middle School. The safety of 700 students and staff was immediately in danger when the bomb threat was posted on Twitter at 6:52 a.m. by the account at SchoolSocks115, which is owned and controlled by RJN. And in conclusion, RJN was not under custodial interrogation for Miranda purposes when moved from class for an alleged bomb threat. And we ask you, Your Honor, disregard this attempt of RJN's lawyers to protect him and find him guilty for making a bomb threat which endangers the lives of 700 students at Hillcrest Middle School on May 1st, 2007. Thank you.
Counselor, I have a question for you.
Yeah?
You were talking in terms of the public safety. If Officer Finch was so concerned about the bomb threat, then why wasn't the whole school evacuated immediately upon learning of this tweet?
Because the school wasn't evacuated quickly, but we believe that appropriate measures were taken, and the fact that school wasn't evacuated quickly because they first wanted to investigate whether the tweet was real or not, and in order to investigate whether the tweet was real, they had to interrogate RJN, and the interrogation was quite fast, as they did the interrogation in 15 minutes, which is quite fast considering that RJN denied to answer every question by shrugging whatever questions are. And RJN was not cooperating with the police officers, which took so long for Officer Finch to ask the questions, or else the evacuation would have been much faster.
Thank you. Do you need your phone count?
No, I just need this.
You okay? You turned it.
May it please the court, my name is Cecilia Perez, and I will be delivering the rebuttal today. Now, we must look at some of the points that respondent has made. Now, they say that Officer Finch knew that they said that it was just a simple conversation or whatsoever, but we must look that Officer Finch knew that her actions were reasonably likely and actually did cause RJN to confess, which is a ruling that Rhode Island Vienna's made, that we must look at the circumstances, actions, and the wordings of the questions. Now, that the first speaker also said that he was asked to go to the principal's office. However, we must look at the statement of the facts, and it says that he was actually pulled out of his first period class in order to be interrogated by Officer Finch. And RJN was clearly intimidated, Your Honors. Now, in the statement of the facts, it even says that he was sweating, his palms were sweating, and he was red as Officer Finch asked questions, intimidating, accusatory questions to a 12-year-old. And for these reasons, this is how he showed that he was clearly intimidated. And we must bring up NC v. Kentucky, where it actually says that that JDB actually that NC, it didn't indicate the actions that were made by the officer clearly indicated that NC was in custody at the time of his questioning. And this is very similar to our case because it says that he was taken out of his classroom by an armed officer, and which is the same as this case. And he was also questioned in a closed room. He was never informed to be able to leave. And his parents were also not contacted until after the questioning, and the court held that no reasonable student under these circumstances would have felt free to leave or the right to remain silent. Therefore, NC was subject to custodial interrogation and entitled to Miranda warning. Now, this should apply to our case today. Why? Because it's the same being pulled out of class, being questioned, and not contacting his parents, violating school policy 1320. Now, we also must look at, just as I mentioned earlier, that they did say that one of the factors, that it was only one factor to determine whether it was custodial interrogation, therefore admitting that he was under custody and he was being interrogated at the time by Officer Finch. Now, they also say that he was handcuffed or searched. Now, the courts have said that in order for one to be in custody or interrogation, there is no need to be handcuffed or searched. Now, it's throughout the eye of the beholder, and in this case, RJM felt as if he wasn't free to leave. Why? Because he was clearly told to sit back down by Ms. Clearwater. Their second speaker said that they clearly, it was an emergency, but you must cross-apply all of my partner's arguments, saying that it is that bond has many definitions, and it's up to interpretation. And in this case, it clearly wasn't an emergency. It was not a threat. It did not say, for instance, bomb. It said bombed. And there's many definitions up to this day for that word. Now, their second speaker said that reading him his Miranda rights would have delayed the process of knowing if there was a bomb, therefore already admitting. And he himself said that the interrogation was fast and less than 15 minutes, therefore admitting and proving my point that RJM was in fact under custodial interrogation. And this is why we must vote for RJM's right. We need to give people their rights and look into the effect that this case will have on the future, in the future, and to our citizens right now, to our juveniles, such as we will be taking away their Fifth Amendment rights, and this is unconstitutional. It's in the Bill of Rights, saying that the Fifth Amendment, that we must protect, that suspects have the privilege against self-incrimination throughout two main points, which is one, the right to remain silent, and two, the right to counsel or have legal representation, which was one of the arguments I had made earlier, juvenile warnings. And they also said that it was time-consuming. Miranda rights does not take much time, Your Honor. Clearly, it's something that's done very quick, which is that you have the right to remain silent. Anything you say can and will be used against you in the court of day. And he said that, they also said that 700 lives were in danger, but clearly it was not a threat to the school. And we must take into consideration that if this whole school was evacuated, why was RJN left inside? Therefore, taking out their argument that it was an emergency. And you must reverse the lower court's decision because RJN's rights were clearly violated. And they have proved my own point that he was interrogated and it was fast, therefore proving my point.
You had some comments you wanted to get to? Yeah. You can start with the first one first. Hey, Sean, we're going to put the judge on if she wants to give comments. You got time or not? You want me to send them to you or what?
Actually, one of my counsel has a question.
I'll go.
Yeah, I'd like a rebuttal against what was said about our claims.
Yeah, but unfortunately, the respondent doesn't get a rebuttal in moot court.
All right.
Just like we didn't get one when we had responded too. It's one of those things you can't do, I guess. But go ahead. Well, anyways, let's go with this.
You ready?
Yeah.
I just wanted to thank both sides. Both sides did a remarkable job in their presentation. During the first court, I would have some suggestions for both sides to slow down. I wasn't timing, I didn't have time, so I don't know how the timing went on your presentations by the petitioner and by the respondent, but both sides spoke very quickly. They needed to slow down because their points were missed in several occasions, and I think both sides needed to just take a deep breath, slow down a little bit. And so therefore, in the second court, that was very predominant, that there was a slower pace. Therefore, the points were made and were recognized as well because they were slow and pointed out their points as well. So something to kind of take into account. Also, I know a lot of you spoke about your co-counsel, your team member, or your partner. Those are good rather than using the word she or he or they. Use the professional terms if you can when you're talking about your partner or your teammate or your co-counsel that made a certain point. That really kind of gets everybody's mind, oh yeah, okay, rather than she made the comment, because in the first case it was all young ladies, so which she were they talking about? So that will kind of pinpoint it if that will help. But both sides did very, very well, and it was very, very good to watch and very, very interesting. So thank you for allowing me to do that, and I wish you the best as you keep moving forward and compete further. Is that correct, Mr. Smith?
Yeah, Suzanne's going to try to help us out to where we can petition to go to nationals next year to try to do this in front of an audience in Chicago with YMCA.
Yeah, Michael, we're losing.
Oh, okay. Sorry. I said Suzanne's the lady that would be able to help us with our plight. So I guess we are losing connection somehow. I will send you the ballots. I think you guys did really, really well, and I think Lisa, where she's at, is looking down at us and very proud that we're continuing on after her guidance and spiritual help. Also, I'd like to see if we could sometime later in the week get back.
Michael, I think this was a great experience for my students. Yeah, I'm sure they'll have a lot to say about the experience, and I just maybe in a few weeks we'll talk. Perhaps we can do something in May.
Okay, that would be good. We'd like to have a debate in May. I'll send you a link in a little bit so you can actually watch yourself. And
could I ask one big favor, if possible? Would you be able to take a picture of your group with your honor there and send it to me, just so that I have a record of, and I'll do the same, and we can exchange kind of group pictures?
Yeah.
That'd be great.
I'm doing it right now.
Okay, awesome. So I'm gonna, here, you guys get in. We'll do the same. Like right in front of the flag.
Okay. All right. Okay.
Right in front of the flag. And we can send it to them.
What's
ready? Everybody?
What's your Facebook page?
I got them already up on Facebook.
Okay, I'm gonna send you a picture. Can you guys all wave and say, have a great afternoon from Canada, and we will talk soon enough.
Okay. I will send you our Facebook page because I think we got about 70 pictures up already. Okay?
Thank you.
Thank you. Bye.
Bye. Hey, Michael, just really quickly, will I get a copy of the feed for the for video, or?
I'm sending that. I'll give you a YouTube feed probably within an hour.
Okay.
Thank you.
Thank you so much.
Bye.
Okay, take care, Suzanne. Take care. Bye-bye now.